Hi everyone, I'm JD Hoovener, your host of the Bold Today Show, where you, the inventor, entrepreneur, or business owner, get your daily dose of inspiration to make the world a better place. All right, we're in part 4 today, talking about our top 5 services that we've been giving to clients now for 5 years. It's hard to believe, time flies. This week we've talked about our core offerings for patent law, including the patentability search opinion, the provisional patent application, and the non-provisional patent application. So if you missed those, get a hold of us. We can get you a copy of the video. We'll send you the URL. It'd be great to be able to check out that information. Don't forget, we've got a lot of the more details in our book, Bold Patents, the Inventor's Guide to Patents. This has got the details. We're not going to get to that in this video. I'm just going to give you kind of the teasers. But to dig in and learn more about all these, check out Chapter 8, Chapter 14, to learn more about the search and the applications. All right, today is actually kind of a fun holiday. It's National Scavenger Hunt Day. Really interesting, right? And sometimes that's what it feels like for the inventor and even the patent attorney when you submit your patent application, right? After you've submitted the non-provisional app, it's now in the hands of the examiner, and they're on a scavenger hunt to go find something out there that is going to be like your invention. Their job is to try to reject your invention. Try to find some what's called prior art or a reference that would say that, no, your invention is not new, or that it's just an obvious version of this other article or publication that's been out there now for years. So the examiner is on this wild goose chase, this scavenger hunt. And what's interesting is that what they do when they finally find something, whether they object or reject your invention, as they look at it, they issue what's called an office action. You may have heard of office action. So that's what the patent examiner is going to do if they determine, no, this invention as it is currently written is not going to get through the gate. I'm not going to allow this to get issued. There's something that needs to get cleaned up first. So office actions can range in complexity from something quite simple, which might just be a simple error on a drawing. Or maybe one of the numbers is wrong, or the shading isn't quite clear and the figure number needs to be changed. To something way more complex, which might involve a 35 USC section 101 eligibility rejection. Right? The examiner is saying this isn't even eligible under patent law. They may issue a 102 recitation, which is about, hey, here's at least one reference that says this has already been done before. Everything that you're claiming is under this one or a set of prior art references. And they leave a clear delineation and they cite to what those references are. And you see in that office action the full, the patent or the publication that they've used. So you can look at it and see for yourself whether you think they're right or not. So depending on where you're at in the complexity level, of course, that's where how much level of effort it'll be for your patent attorney to help you with. So it's important that you have an understanding of how complex the rejection is, so you can gauge the likelihood of being able to overcome the examiner's rejection or objection with legal argument or with amendments to the claims. So if someone's looking to, if an inventor is looking to be as adversarial as possible and to try to get as much rights as they can in an office action, they're going to want to push back with just legal argument. Come back with the examiner with very creative legal arguments based on case law about why the examiner may be wrong and why what the inventor has put forward is still very viable under the law. Now, if the party wants to just get the patent issued, right, they're willing to negotiate with the examiner, amendments may be made to the claims. And in almost every case, amendments mean narrowing the patent scope. In most cases, it's adding additional terminology or changing the words to give more of a definition around them to make sure that they're avoiding the prior art reference. And so this, of course, every case is different, and it's going to depend on what your invention area is and the art unit of examination that was assigned. And it's going to be something we should talk about. So if you've got an office action and you want to get some questions answered, please give us a call at 800-849-1913. Or if you have questions and you want to book a free 30-minute consultation yourself, you can do that on our website at boldpatents.com. So if you've enjoyed this session of the Bold Today Show and you feel like you would like to share this with someone who you think might be interested, forward the email. Simple as that. They're going to be able to click on the registration link themselves and get signed up to receive this daily message just like you are. So again, thank you for listening, and I appreciate all your comments. Again, I forget to mention this too much, but when you can, please put in comments and feedback. We'd love to hear about how we can improve the show, get some additional topics to allow you to hear what you're hoping to hear. I'm your host, J.D. Hoovener of the Bold Today Show. It's been my pleasure talking to you. Have a great day, everyone. And go big, go bold.